Romeo Chico is a founder of Paymaster. He's going to tell you a little bit about himself and his business, and you'll learn and you'll hear and see for yourselves how qualified and competent Romeo is. Romeo, I turn it over to you.
Hey, good morning, everyone. And and thank you again for this opportunity. As Steve mentioned, I started Paymaster payroll service here in Palm Beach County over 25 years ago. Over the 25 years, we've expanded into offering time and labor services, HR information system, and we're now servicing companies in all 50 states, Puerto Rico, U.S. Virgin Islands. And whether you have a one-person company or a company with thousands of employees. So my contact information will be on here. I've been heavily researching all of these acts for our clients. There's a lot of information, and I try to put out weekly updates to our clients and keeping them informed. And kind of came across Steve a couple of weeks ago, and we've partnered up on a couple of these webinars where I'll talk about the act, and then Steve will come in and talk about the kind of the application and the law aspect of it. And in this case, and how this may apply directly to your firms. So let me share my screen here. Oh, Steve, you want to allow my screen sharing?
Go ahead, Romeo.
All right, looks like we're up now. All right. So there are two main acts that apply to employers. There's talk about a fourth, another one coming out will be the fourth, but there's two that really apply to the employer and business and payroll side. The first one that came out was signed March 18th. It just became effective April 1st. There's a non-enforcement period of 30 days from the signing, which is up on April 17th. Department of Labor says, there's not a grace period from the 1st to the 17th. You have until the 17th in order to put these things in place, and you need to go retroactive. So this is, for all intents and purposes, has started April 1st. Go. This is an overview. There is a lot that is changing on a regular basis. I've seen Congress come out and amend one act with words or language that was their intent, but their intent wasn't well worded in the original act. So they've made corrections. And I've also seen Department of Labor translate sections of the act in certain ways, and then Congress come in and send scolding letters to Department of Labor saying, no, that was not what we said in the act. So I'll point out some of these things that have changed over the last couple of weeks. So this is subject to further defining and tailoring as it gets rolled out. The Families First Act applies to all employers with less than 500 employees. So if you have a one-person firm, this applies to you. And you are now required to give the employees 2 types of paid leave, in addition to whatever leave you may already have in place. It's an emergency sick leave and an emergency family medical leave. And the employee must be unable to work or telework. So if they can work from home, they would not qualify for these 2 new leaves. And these 2 leaves go away at the end of the year. There is no carryover. There's no payout of unused leave. You use it between now and the end of the year. There are 6 very distinct reasons for taking this leave. I have them numbered here, and the numbering is important. It's a consistent numbering that Department of Labor uses and the Act uses. The top 3 are reasons for the employee's own personal benefit. The employee is subject to a quarantine or isolation order. Now, a couple of weeks ago, that was defined as A quarantine or isolation order, you look at Health and Human Services, they are very specific definitions, and it did not count as a stay-at-home order, as we're now subject to in the state. This was recently modified. That says a stay-at-home order does count towards number one. Number two, the employee is advised by a healthcare provider to self-quarantine. So maybe maybe they went to a doctor, maybe they don't have the symptoms, but the doctor said you should self-quarantine. That's number two. And three is the employee has direct symptoms. They are experiencing the virus. 4, 5, and 6 have to do with the employee's care of someone else. So they have a family member that has fallen ill or subject to an order. Or number 5 is simply the employee has a child who's in school that's under the age of 18, then they qualify for 5 without anybody experiencing any symptoms. So here's where I identified that this was recently added, that it includes the shelter in place or stay-at-home order. It is kind of a catch-22, I think, because it says the employer has to have work you could perform, but you have to perform the work at the place of work and you can't do it at home. So it's a little tricky, because I look at it as, well, if the business is closed because of an order, then there is no work that can be performed at the business. So like a restaurant, so the employees are not subject to receive this. So it is a very tricky law, I think. Now, violations of this, to kind of sidebar here, a violation of this will be a violation of a minimum wage. So I can see the possibility of minimum wage violations and lawsuits shoot up, because people will think that they're eligible for this and maybe their employer was closed or said they were closed, and this could generate some lawsuits. Now, going back to how long an employee can be out, it's specific to the reasons. So 1 through 4, so all the employee reasons or the employee's caring for someone. And number 6, the employee gets 2 weeks of paid leave. It's 80 hours, 10 days. If the employee is part-time or they work a variable number of hours, it's the hours that they would have worked, or the average number of hours they have worked in the past. So if you have a person that always works for you 20 hours a week, and you just have that one person, that person is eligible for an average of 20 hours a week for 2 weeks, so 40 hours until the end of the year. Now, reason 5 was the reason that the employee is out because they have a child at home out of school. That person gets 12 weeks of paid leave. And again, if they're part-time or variable, they get a prorated amount of that 480 hours over that 12-week period. So it is fairly long. How much the employee gets paid, again, depends on the reasons. 1 through 3, so the employee is out for their own personal reason, their personal care, they get up to $511 per day. So whatever their regular rate is, that is a fairly high rate of pay. And for 10 days, the maximum for the year is $5,110. For reasons 4 through 6, the employee only gets paid 2/3 their regular rate of pay. And up to, so $200 is the maximum there at 2/3. And at 10 days, they're limited to $2,000. Now, we did say reason 5, they're allowed 12 weeks. So they get that $200 per day. up to $12,000 over the 12-week period. The only one that has a condition that the employee had to have been with you for a period of time is number 5. The employee must have been employed for more than 30 days. So reasons 1 through 3, 4, or 6, you could hire the employee one day and the next day they're now eligible to take this time off. What's been happening recently is companies have laid off a large number of employees, and now with the payroll protection loan that we'll talk about in a moment, they're kind of being forced to hire those employees back. When that employee is hired back, they don't start the 30-day clock again. When you hire them back, it's as if they never left from their original time they were terminated. So that is an important thing to note there, that 30 days. So now that the government is mandating you to pay out all this leave, potentially thousands of dollars, you are getting that money from the government. So you're just providing a government benefit. You will get a tax credit for the full amount of wages you pay out under this leave. You will get a tax credit for your share of employment taxes and for the employees, your share of health insurance. So the government is trying to make you 100% whole for continuing to pay these people out on leave. You're able to take that tax credit immediately on your next tax deposit. So you are getting those funds right away. It is possible that your tax credit could exceed the total amount of taxes you have due. If that occurs, the IRS just came out with this Form 7200 last week. You send in this form. They are promising, at first they said as soon as possible. They've later defined it as it should be 2 weeks, that they will process a refund if the credit exceeds the tax due. So with this Families First Act, it also expands the family medical leave, but it's only for that reason number 5. So an employee is out because they have a child out of school. It gives them 12 weeks of job protected leave. So when that person comes back in 2 months, that job needs to be there for them. There are a couple of exceptions. So if you have less than 50 employees, you can opt out. At first, Department of Labor said there was going to be a filing, and they have later come out and said there's not going to be any filing. You just do it, and I guess if they come in and investigate, you have to show that your business would have been jeopardized if you honored this. I heard they're not taking it lightly, that they really want these people to be hired back. They've said, if you don't have the job available when they come back, that if you have a job available in the next year, that you seek out that person and offer it to them. So this will be very interesting to see. And again, I foresee there will quite possibly be lawsuits that arise out of this, of people saying, hey, I tried coming back, there was no job, and now 8 months later, and I find out someone else was hired, and they didn't contact me. If you are fewer than 25, there are some other exceptions in there as well. So the second act which came out is the CARES Act. That was signed March 27th. Each part of it has different effective dates, so we'll talk about this on these slides. It is a huge act. It's over 900 pages, I believe, whereas the Families First Act was only about 200 pages. I read the Families First Act a few times. This one, I have not read the whole thing, just these 3 related sections to payroll.
Romeo, can I interrupt for a second?
Yes.
Some people want to know and have me confirm now that your slide presentation and mine will be made available to everyone after this presentation. So I want everyone to know that in case they're worried about having access to it later. Go ahead. I'm sorry.
Mm-hmm. Sure. All right. So there's 3 main pieces of this act that apply to employers and businesses. The first one is you can defer your share of Social Security tax on payrolls between now or March and the end of the year. There's a little confusion. It is only your share of Social Security tax, which is roughly 6.2% of wages. The IRS still wants all of the other payroll taxes. So anything withheld from the employees, Medicare, your federal unemployment, they want all that. It's just your share of Social Security tax. And anything you don't pay, at the end of the year, they'll look at that amount. Half of it will be due at the end of December 2021, and the other half, December 2022. So they're giving you a very long time to pay in these taxes. Not quite sure how they're going to manage it. I don't know if they're going to send a bill at the end of the year as to what you've deferred, or if you just have to track it on your own. They have other priorities than coming out with that right now. The second one is the employee retention credit. This says that half of the wages you pay your employees, you can take as a tax credit on that tax return, on that payroll tax return for that quarter. You do have to qualify for this in that your business has to be fully or partially suspended. So a great example of this are the restaurants. Or a significant decline in revenue that has been defined as 50%. So if you haven't been suspended or shut down from the government and you just don't have business, 50% compared to the same quarter last year will make you eligible for this. So it's not bad. It's a $5,000 maximum credit per employee over the course of the remainder of this year. You've got 10 employees, that's $50,000 tax credit that you take right on that, on your next tax deposit. Again, if the credit exceeds the amount of taxes you have to deposit, you file that same 7,200 tax return and you'll get a refund in a couple of weeks. The third piece, which is the big one right now, is the Paycheck Protection Program, or PPP. It's eligible for eligible businesses less than 500 employees. The amount you get is 2.5 times your average payroll. There's been a lot of confusion about this with the banks, whether it's the 2019 or the 12 months ending yesterday. I think all they're trying to do is you come up with your average month, 2.5 times that, up to $10 million. It is initially a loan with a payback of 2 years of not greater than 4%. But if you spend your money that you receive, actually I'll go back to that, on certain expenses, you can get that loan forgiven. And I'll go over those reasons in the next slide. Of these 3 things, you cannot take advantage of all of them together. You cannot take advantage of the employee retention credit and the PPP. So it's one or the other. Either you're getting free money or you're getting half of the wages. I've reviewed companies, And there are some companies that would make out better with the employee retention credit. If you have a lot of low wage earners, this may be the better route than the Paycheck Protection Program. You can't take advantage of the Paycheck Protection loan forgiveness and the tax delay. Although the IRS came out recently that says you can take advantage of the tax delay up until the point your loan is forgiven. I've read the act. It is not what is stated in the act, so I'm advising clients, be cautious with that. Take a screenshot of the IRS that's telling you it's allowed, because that could come back and say that's not allowed. And the employee retention credit and the delay of tax. So you can't take the credit against your family's first wages. So there's certain combinations you can't do there. Now, to get the loan forgiven that you receive, I spent this past weekend, I wrote an article on this that's very detailed, as well as I created a calculator. It is very complicated, but there's 4 pieces. The loans must be used for payroll costs, rent, interest on mortgages, or utilities. And each of these things had to have been in place prior to February 15th. So if for some reason you've just started a brand new business after February 15th, you cannot get loan forgiveness. The rent had to have been in place. Everything had to have been in place prior to February 15th. 75% of the loan disbursement has to be spent on payroll. So if you spend any less than that on payroll, that amount is not deferred. I've talked to a number of companies that are looking to decrease their employees' wages. So if they had an employee who was earning $100,000, they're telling them, look, we don't have money, we have no business, I'm going to cut your wages down to $60,000 until we get out of this. You can't cut anyone's wages by greater than 25%. Otherwise, that amount is not forgiven. The amount that's greater than a 25% cut. And they want you to, this is the whole name of the section is Paycheck Protection. So they want you to pay your employees with this money, the same number that you had pre-COVID-19. So there's a look back period. They're saying, look at this, basically the same quarter last year, and that number of employees you need to have on average through the 8 weeks of your loan. So if I had 20 employees back then, and now I've laid off 10 of them because I have no business, half of my loan is not going to be forgiven. I need to bring back those employees. And I've had a lot of discussion with clients of, well, what do I have the employees do? The government doesn't care what you have them do. They really couldn't care if they just sat there and did nothing. And the Treasury Secretary said it on a press conference a couple of days ago. And he said, basically, we're just substituting unemployment. We're giving businesses the money to, in essence, pay unemployment so that when the nation is ready to open, you have your employees on staff. They're going to go from possibly doing nothing to now working, and you don't have to rehire. So he said, every dollar we spend on this is a dollar saved on unemployment. There's a lot of employers that find that challenging, of paying an employee for doing nothing or finding some sort of minimal work, but they're getting that loan for that purpose of paying the employees. So they're expecting that to be used for. Talking about unemployment, this is a section I came across about 3-4 weeks ago. And for those that are making the decision to terminate their employees because there is no work, great. You need to identify to that individual that it is for the purpose of COVID-19. Hopefully the individual states that to the state when they make their unemployment claim. But more importantly, when you receive that unemployment claim notice from the state and you answer it, you need to identify that it is for the sole purpose of COVID-19 that person was terminated. Because of this statute, the claims that the employer or the state will pay to that separated employee will not go against your record. And when I look back at 2009, there was a lot of terminations back then, and your unemployment tax rate will go up or down based on claims against your record. There's a few other factors, but the majority of it is because of claims paid. So with the 18 million people filing for unemployment, rates would have normally shot up. And back in 2010, it was not uncommon for us to find the majority of companies out there with the highest unemployment tax rate. But because of this, at least in Florida, and I don't know if every state has this same statute, but your rate should not be affected. So, all right. So I know I went through a lot of information, and there is a lot changing on a regular basis. I put out this web page off our website, paymaster.com/COVID-19, or if you just go to paymaster.com, there's a big banner right on the homepage. I drive my IT staff crazy because every night I research, I get new information, and I'm sending them changes. So that is a great resource. I have everything out there. But if you do have any questions, my email address is there. We'll try to get through questions today. But if I don't get to yours, or you come up with a question tomorrow, please feel free to reach out to me. So,
Romeo, that was exceptional. Thank you very much for your presentation.
Yeah, very welcome.
Romeo is an expert in his field, dealing with payroll and these related issues. I've known Romeo for, more than 10 years. We've done numerous presentations together for his clients, my clients, and he's a fountain of useful information and very responsible and helpful, as you know. Romeo, you made a few comments about all the lawsuits that are going to be filed, and that got my attention, I think, more than anything else. I'll be addressing some of those points in my remarks. Kathy Clark of the Bar Association wants me to remind everybody that the CLE number for this course will be sent out this afternoon. So everyone who's registered and is participating will get a communication. I said earlier, in case a few of you have joined since, that these slideshow presentations will also be made available to you, so you'll have that benefit. And I'd like now to present my presentation, and feel free to chat, hit the chat button on the bottom by moving your mouse there, and we'll try to be as responsive as we can. And likewise, if we don't get to your question, you'll know how to contact us, and we'll be very happy to be responsive. So I'll begin with that. I want to thank everyone for muting their microphones. It allows us to present without the background noise, etc. So thank you very much. So let me see if I can start now. I assume everyone can see the screen. The title of the course, Through the Bar Association, COVID-19 Resource Guide for Law Firms and Employment Law. Here we go. Excuse me. So we're not in Kansas anymore. The whole world's topsy-turvy. whatever you hear about what could or should be done, one size doesn't fit all. Employers, law firms need a customized approach that's necessary and particularized for any given business or law practice. And obviously, the right course of action depends on numerous factors, and our environment is dynamic and ever changing, so by the hour. So just please keep that in mind. A lot of what we recommend or advise our clients to do, or we do ourselves, has to do with whether we're essential business or not. Are we open or closed, in whole or in part? Are employees, were employees furloughed, or are they furloughed and still on the employer's roster, or were they terminated? Are they being hired back now that the PPP funds are starting to become available? I do have some clients who actually have received the PPP funding. The banks are in a race to see who can get their documents prepared, signed, returned after approving applicants, and get money into the accounts of clients, and that has already started last day or so. Other issues have to do with whether the employees are able to work at all because maybe they're sick or incapable, or caring for someone, or caring for children home from school, and are they able to telework? That affects and impacts obviously whether they're entitled to receive the family's first leave payments, etc. Are the employees themselves afflicted is a factor, obviously, and are they caring for a family member, etc. So I'd like to present some initial pragmatic items to consider. A lot of these comments apply to businesses in general, employers in general, but certainly as to law firms, in as much as law firms are employers. In the services industries, let's face it, we're in the cloud to stay. As far as manufacturing and hands-on, it's not the same. But teleworking is now the norm across the board. And when we get past this crisis, it's going to be really hard to go back to the way we were. I recall, I'm old enough to recall the days when law firms had large footprints of law libraries in their law firms and paid a lot of premium rent to landlords and made landlords rich just by holding these books. That went to the four winds a long time ago. So a lot else that we do now in the practice of law will change forever. As you heard from Judge Small, we have web-based court hearings now, web depositions, client meetings, mediations. The United States Supreme Court announced yesterday or the day before they would conduct oral arguments via web conference, real estate closings, board meetings, and everything else, obviously via the web will become more prevalent. Florida bar meetings may very well transform and take place in a digital online conference format as opposed to in person. There will be a tsunami of employee claims before we know it. They've already started. And one tip is if your business does not already have employment practices liability insurance, EPLI, it should be obtained immediately to cover the feeding frenzy that's going to occur, so that defense counsel can be appointed and damages can be paid out if those employee claims fall under the provisions of the EPLI policy. But we've had, monstrous disruption in the workplace, and what that will do is it will bring out of the woodwork all the claims that employees think they have or do have, and will lead them to actually bring the claims. When you're employed and you're getting a paycheck, sometimes you don't bring a lawsuit because you don't want to lose your job or jeopardize it. So now that someone doesn't have a job where there's been this disruption, a lot of claims will come forward soon now. And then, of course, because of what's going on, there'll be a new avalanche of suits in view of the new laws and regulations, et cetera. Romeo gave a good example of one typical one that pops to mind. Can you imagine an employee filing suit who was let go, was told that the position was eliminated, and they find out later the position is reinstated in effect and someone else got hired. Under the fog of war, there may very well be discrimination kind of claims where it may be that employers sort of take advantage of the situation and let go some employees who they would not have let go previously because they didn't want to get sued for discrimination, let's say, and they could be using this as an excuse. So there'll be a lot of employees and lawyers who will be making these kinds of claims, among many others. There will be an onslaught of whistleblower claims. Under Florida Statute 448.101, whistleblower claims can be brought, for example, where an employee objects to the company violating a law, rule, or regulation, and as a result becomes a victim of retaliation in the form of some form of adverse employment action. And we can only imagine that with as difficult as it is to understand and implement and follow up on all the new legislation and new laws, rules, and regulations that are coming out by the hour, we can all imagine numerous employees making complaints. They can be made orally. They don't have to be made in writing to have a basis for suing. And then if negative action is taken against an employee, the employee could claim later that they were retaliated against and they're a whistleblower. We also know, based on the recent impeachment hearings involving the president, the role that the whistleblower can play. And a lot of people have been informed of the potentiality of being a whistleblower. And that will be widespread for sure. Also, we're expecting a large number of False Claims Act, also known as QTAM claims being filed, where a private citizen is filing a lawsuit claiming that a person or company basically violated the law in the performance of a contract with the government or in violation of a government regulation. Maybe a company being alleged to have falsified records and computations. Everything's happening so fast that you can almost see the various people filing claims, pursuant to which, if they're successful, maybe the government takes over the claim and prosecutes it, in which case the person filing the action initially, really was a private whistleblower, could get a percentage, sometimes 20 to 35% of the recovery, plus the attorney can get attorney's fees. So I'm predicting there's going to be an onslaught of False Claims Act claims for years to come. Another tip is that if you're an employer who decided to furlough employees, and that's sometimes also referred to as a temporary layoff, as opposed to a permanent layoff or termination. If you've furloughed employees, and they're still technically your employees, sometimes you've done that because you want to make sure they still have insurance, they're still part of your group insurance program. You have to remember as an employer to continue to make sure you make the full insurance premium payment, especially where the employee was paying part, but now all of a sudden is furloughed and not contributing. So you want to be sure to do that to keep those benefits in place. You may want to speak to your insurance broker to make sure that under the policy you have, the carrier will not claim that those furloughed employees were not actively working and therefore allowed to be part of the group policy. And if necessary, you may want to have your broker work with the carrier to change the provisions to make sure that that's not a problem. Record keeping for all employers of all kinds are important, and with people teleworking and businesses shut down, it's going to be hard to keep track of record keeping. How many hours are employees working, etc. Calendaring for law firms. We rely on each other and interact with each other to make sure that all the important events that occur in our legal practice are calendared with reminders so that we don't let statutes of limitation pass or deadlines pass. On that point, with as difficult as it is to practice law remotely the way we're doing it, different than most of us have done in the past, it's reasonable to assume that there'll be more malpractice and more malpractice claims. So I think lawyers and law firms need to be very careful to make sure that they're not doing the kinds of things that could result in a malpractice claim. Additionally, there's no suspension of Florida bar rules regulating the Florida bar and ethics. So lawyers have to be cognizant of and be sure to follow all of the rules and ethics that we're obligated to follow. We have to maintain attorney-client privilege, confidentiality, make sure work product is protected, and non-client people aren't getting access to or seeing the private confidential communications we're having with our clients. Other issues related have to do with privacy and with regard to recording. We're recording this Zoom conference. It's announced it's not a private conversation where people would expect privacy to apply. But Florida is one of the 3 states where it's criminally forbidden to record without getting the consent of everyone involved in the conversation. So you and your clients want to be careful as far as with everyone working remotely and teleworking, what gets recorded and what doesn't get recorded. And if something's going to get recorded, make sure the person consenting, the people consenting, are on the recording itself. Also, you have to safeguard trade secrets for businesses and others. Under Chapter 688 on misappropriation of trade secrets, someone can bring an action, but only if you can first demonstrate that you exercise reasonable measures to ensure that what you believe is a trade secret or confidential, proprietary, that reasonable steps were taken to protect. So with everyone dispersed to where we are, it's a bigger challenge. So one place to start with is a discussion about who are your employees. Companies think they know who their employees are, but very often businesses try to, either on purpose or by accident, misclassify workers as independent contractors because they can avoid a lot of expense and a lot of exposure for protections that employees have. So in knowing if you're learning what your obligations are with regard to your employees, you need to know pretty well who are your employees and who are your independent contractors. So that's important to consult with a professional for that purpose, you, lawyers, or others. The 11th Circuit has for a long time adopted the economic realities test. There are 3 tests that apply generally. One is the Department of Labor on overtime related matters, IRS with regard to tax matters, and then common law with regard to agent principle and those kinds of vicarious liability kind of issues. But the economic realities test is well known. There's 6 parts to it. I won't read the entire slide. You'll get a copy later. But it has to do with these factors. The court decides how many of these factors are on one side or the other and what weight to give. And that's within the court's discretion to make that decision. And these are familiar to most of you. Is the work being performed an integral part of the employer's business? Is that supposed independent contractor doing the same thing that the business does, the owner of the business does? Does the worker's managerial skill affect the worker's opportunity for profit or loss? Is it just a flat rate per hour, and what the worker does or doesn't do doesn't really change how much profit can be made by this separate independent contractor? How does the worker's relative investment compare to the employer's investment? Who's using what means to perform the services, and who's investing what money, and who's creating a lot of the workplace environment? Does the work performed require special skill and initiative? If it does, it's more likely the person is an independent contractor. Is the relationship between the worker and the employer permanent or indefinite? A lot of people mistakenly believe that if the worker actually works for someone else or other people, that sort of automatically means they're an independent contractor, and that's not true. You can imagine a bartender who works for a business 30, 35 hours a week as an employee in truth, because the other factors apply, and then moonlights as a bartender someplace else on the weekend or part of the weekend or during the week, etc. That person could be an employee of the first entity. What's the nature and degree of the employer's control over what the person does and how they do it? So these are factors that are involved, and you need to make this analysis. One main area that will apply very quickly has to do with the Fair Labor Standards Act, dealing with overtime and minimum wage claims. As you already know, if there's a violation of the Families First Act with regard to making payments that are required to be made for leave under the statute, those claims are brought as minimum wage claims under the FLSA. Trust me, there are a lot of claims filed under the FLSA. There'll be a lot more filed later because there are going to be a lot of mistakes. And it's a prevailing plaintiff attorney's fee statute. And right now, about traditionally, 25% of all employment-related claims filed in federal court are FLSA actions. That number and percentage, I think, will increase significantly because of what's happening for a number of years. Florida's minimum wage is $8.56 an hour. Time and a half is $12.84. And the Florida statute of limitations for minimum wage can go back as much as 5 years if the employee can prove that it was knowing and intentional. So there'll be potential exposure for a long time. So you want to make sure, and clients want to make sure that they do it right. Issues will come up as to who's exempt and non-exempt. As you know, if someone's exempt from overtime, it's because their duties and responsibilities that they actually perform qualify them for the exemption, not merely because they're paid a salary. You can't make someone exempt just by paying them on a salary basis. If they're exempt, the only way they can get paid basically is by salary. So it's not the obverse. And what will happen is when a hurricane hits and some kind of catastrophe hits, and this is one of them, very often your exempt employees are asked to perform duties that are non-exempt kind of duties, and the old exempt duties they're not performing at all or as much. And as a result, the status of exempt employees may change because the duties change, in which case you have to change their status and basically move them over to non-exempt and make sure your payroll company or your internal payroll keeps track of their hours and pays them overtime at the correct rate. So that's going to be very important. On the backside, when things get better and those kinds of employees go back to performing those exempt duties, you want to document it. You want to do a job description. You want to show that they used to, maybe they were exempt, paid salary, they went non-exempt, they've come back to exempt for these reasons. So you can justify it later if you have to. Let's talk about paralegals for a second. But before we do, interns and law clerks. For many years, law firms actually didn't pay law clerks, summer law clerks, because they were affording them this great privilege to be a law clerk for a law firm. And I think it's become much more well known now that law clerks have to be paid, certainly at least minimum wage. And of course, they're paid a lot more than that now. Paralegals, when the Department of Labor regulations were changed, I think in 2008, it was generally established that paralegals generally are not exempt. There are a few exceptions that are actually listed and referred to. If the paralegal is a registered nurse working in the med-mal area, for example, or there's a construction litigation law firm and the paralegal has particular, let's say, is licensed, structural engineering, but they're doing paralegal work, they're not doing lawyer legal work. Those kinds of very particularized paralegals can be deemed to be exempt, but everyone else is not exempt. There was a recent case in West Palm Beach where a law firm was victorious in arguing that the paralegal in question was in fact exempt, and we'll see whether that stands on appeal if an appeal is taken. But if a paralegal is supervising the other paralegals, there may be an administrative, or executive white-collar kind of exemption from overtime, but otherwise they're not exempt and have to be paid overtime. So with teleworking, be very careful about making sure you're keeping track of hours of paralegals and paying overtime at the correct rate. And the other thing is, remember, from an ethics point of view, a lawyer has an affirmative obligation to supervise the work of a paralegal. It's one of the reasons why paralegals generally are not considered exempt. They're not in charge, and lawyers must supervise. And if you're dispersed, it's harder to supervise paralegal work when you are so dispersed. So be very careful. And you don't want your paralegals to be so dedicated and so helpful and take so much initiative that, in effect, what they're doing is the unauthorized practice of law, especially with the teleworking going on. So you want to keep track of hours. The other thing is you want to make sure you can have a policy that says no one works overtime unless they get prior written permission. If they violate the policy, they must be paid the overtime because they worked it. But you're allowed to discipline the employee by basically writing the employee up and saying, look, we have a policy, you violated it, we're going to pay you. Don't do it again. If you do it again, you'll be subject to discipline, including but not limited to termination. So you can try to monitor the situation that way. You also want to avoid retaliation claims. Under the FLSA, if someone makes a claim for overtime and suffers an adverse employment action, which under the United States Supreme Court Burlington decision could be just about anything, either at work or away from work, as far as an adverse action against the employee, there could be a retaliation claim. So you want to be careful about that, and the complaint can be oral, as I said. There are a variety of employment claims that could be brought that we can anticipate. I referred to some of them. There'll be all kinds of wage claims. Under the case law you're all familiar with, wages can be deemed to be things like hourly pay, salary, it could be commissions, bonuses, severance pay, etc. So there are a lot of things that constitute wages under 448.08. That's the statute that provides that if someone brings a claim for wages, whatever those wages may be, that person is entitled, actually the prevailing party may receive, not shall, may receive an award of attorney's fees. The court has the discretion to give fees to one side or the other, or give no fees at all. But most of the time, when an employee prevails, courts most of the time do award attorney's fees for the plaintiff. So there'll be all kinds of wage claims, and because there is availability of attorney's fees awards, there'll be enough attorneys out there interested in representing those clients. There will also be claims related, as we've been saying, under the Families First and the CARES Acts. Employees will allege all kinds of things, including, we won't be surprised if an employee makes a claim that they were somehow damaged or disadvantaged because the employer mishandled the myriad of options available, and they suffered, and the employee didn't do what they could have, would have, should have. Is there a established a body of law that would support those kinds of claims? Not yet, but I won't be surprised if someone tries to develop it. Unemployment, all of a sudden, is a vital area for employment lawyers. Employment lawyers, touched on unemployment issues and didn't have that much to do, but now it's vitally important because everyone's doing a calibration and doing the algorithm. Is this employee better off, or is the business better off by terminating the employee, allowing the employee to make a claim because the termination was based on COVID-19, and get in Florida $275 a week plus $600 a week, $850, $875 a week. It's annualized, it's about $43,500. There may be a limited number of weeks for which it's available, but if the past is any indication, that could and will be extended. So it's important to know how to advise your clients about issues dealing with unemployment. Be careful that you, in responding as an employer or representing an employer, in responding to the reemployment agency that handles unemployment, be careful not to write something in a way that makes it sound like the person himself or herself actually was diagnosed or was suffering or was entitled to reasonable accommodation or FMLA, and instead the employer just terminated them. Be careful not to say that, because that would be an admission that you basically, you may say that to help the employee get unemployment, but it also may unwittingly expose the employer to claims for discrimination or retaliation. Current disruptions are going to unleash a lot of Title VII claims. We're under the federal statute or the Florida Civil Rights Act, where employers have 15 or more employees. There'll be all kinds of claims for discrimination, harassment, hostile working environment, and or retaliation for all of the protected categories, the gender, religion, race, national origin, disability, age, etc. And I think especially based on disability, with people being sick or perceived to be sick, and also based on age. On April 6th, which was 9 days ago, the United States Supreme Court issued a decision saying that if that someone can bring an age claim if they satisfy the requirement to show that age was a reason for the adverse action, as opposed to being the sole reason for the adverse action. When these kinds of emergencies take place, there are some employers who will purposely get rid of, quote, get rid of older workers who they think are dragging what they're doing or not up to speed on technology or something else, and will get rid of and not bring back older workers. So I believe you're going to see a large number of claims brought due to ageism, which is what it's called now. And it's going to be very prevalent, especially as the baby boomers are getting older and the age of workers in the workforce is actually getting higher. And people are working longer, especially in these tough times. There'll be disparate treatment claims. We have to avoid hateful expressions. The last couple of months there have been instances of anti-Chinese prejudice and discrimination related to the Chinese virus, etc. And employers have to be careful not to allow anything like that to take place in the workplace. With employees teleworking and using a lot of texting and email, people tend to write things and send pictures that they think are funny, and they circulate it, and they may even send it to people that didn't intend to get it. And all of a sudden you've got discrimination, hostile environment claims that could be brought. If everyone was working face-to-face, people wouldn't say or do the things that they might be doing now that they're working from home. Under the FMLA, for example, the Family Medical Leave Act, where an employer has reason to know an employee has a serious health condition or otherwise qualifies, the employer has an affirmative obligation to provide FMLA paperwork. So an employer has to be cognizant and aware of which employees may very well qualify if they learn about it. If it's kept a secret, the employer is not charged with knowing what to do. If someone's out on regular FMLA leave, the employer must maintain their insurance. Under the Americans with Disabilities Act, if the employer knows or has reason to know an employee has a disability or regards or perceives the employee as having a disability, the employer must engage in what's called the interactive process to communicate back and forth to see whether the employee needs a reasonable accommodation. That's another area that a lot of claims will be brought under. A lot of lawyers don't know that the National Labor Relations Act, NLRA, prohibits employers who retaliate against employees who are basically participating in what's considered concerted protected activity, where they might be joining together to complain about the employer or work conditions. So if employees go on social media and start talking about how rotten their employer is, and employees fire them as a result, that could be a violation and retaliation. Just a few days ago, Amazon fired a worker who was protesting working conditions at Amazon. And maybe you all saw the news the last couple of days. There was a pork processing plant in South Dakota, which had, with people working very close together, one person tested positive, and the employer did nothing, I think did nothing, was alleged to have done nothing to deal with that situation. It's now a few days later, they reported that over 500 co-employees are now have tested positive. Those are employees who went back to their homes and may or may not have had symptoms and lived with and breathed on and touched and did the spreading of germs or otherwise, the virus or otherwise, and presumably infected a lot of other people. So and that's a state that does not have a shutdown or shelter in place rule out in the state, and that company can't be the only company that has a similar problem. So if you have one employee who's complaining, you may want to consider the potential ramifications. There will be an explosion of corporate bankruptcy filings. There'll be employee-related issues abounding, no question about it. We're facing a major disruption. That's the trend. There'll be aftershocks. There's a general expression that litigators sort of understand more than other lawyers or lay people. It's a little crude, but there are a lot of litigators who shake their heads up and down when they hear it. When times are good, litigation is good. When times are bad, litigation is very good. Everyone's going to have a claim. Everyone's going to have a problem. You have to seek redress in the courts. So that's what is going to happen. A wide range of employment-related. Force majeure is going to be a critically litigated issue. Impossibility of performance. Time of the essence clauses under these circumstances. There'll be intellectual property litigation, bankruptcy, tax treatment issues, a lot of nursing home elder care claims. Nursing homes and veteran homes are being hit with 30, 40, 50 people dying in a particular nursing home or VA facility. It's going to be coming to the fore the next couple of days and weeks. A lot of insurance, business interruption claims. Businesses are going to find out that their business interruption insurance wasn't what it was made out to be, and they don't get a full recovery. There are HIPAA privacy and security issues. Question, are cannabis companies that sort of operate in violation of federal law allowed all the federal benefits that we're talking about? Some states have taken position, Ohio and another state, I forget which, maybe Mississippi, have taken the position that abortion clinics are not essential businesses. That's being litigated. There are bar ethics issues that face us as lawyers, cybersecurity claims, etc. Fox News just got sued for propagating misinformation. So there are all kinds of suits that we hadn't seen before are going to be filed. I'm going to wrap up in the next couple of minutes, the next minute or so. Avoid mistakes if you're implementing sick leave policies. OSHA has a general duty clause to have the workplace be safe, and the employer has a duty to make sure that the employer is not allowing an unsafe condition to exist, whether that means people who are affected working in the workplace, etc. Even though we're on lockdown, people are teleworking right now. Apply policies consistently so you don't get accused of discrimination, and don't ignore your leave laws. Avoid individual liability. If you're a principal or a manager of an employer, sometimes you have a situation where you have joint employment liability, joint enterprise liability, alter ego, mere instrumentality. So don't think employers can hide behind, the principals of employers can hide behind the company. They may face individual liability. There may be some tax liabilities. If you get sued for FLSA, overtime or minimum wage, there's individual liability, FMLA, certain torts, intentional torts, etc. A few good practices. Last page. Communicate with your employees. Explain, respect, and protect their privacy. Excuse me 1 second. Yeah, I'm just about finished. Respect and protect their privacy. Comply with HIPAA requirements. Review your company leave and other policies. Revise your handbook as may be necessary. Document, retain documentation, back up, explain your decisions. If you're going to give severance to people after terminating them, at least get separation agreements back with general releases. Avoid committing fraud or insurance fraud, or your clients doing it, rather. And make sure COBRA is administered timely. Respond timely to unemployment claims. And basically, I think that's what I've spoken on today. The last point I want to make is maybe where we started, and that is the best thing you could do as lawyers and as advisors and counselors and employers is to remain human and realize that there are real people out there and they're dealing with their issues and problems. Sorry for rushing through it. This will be available to you. Thank you for listening. I'm going to come back and end the slideshow at this point.